We have a quorum. I call to order the meeting of the subcommittee on 6 pieces of subsidiary legislation relating to the implementation of the uncertificated securities market regime. I welcome representatives of the administration as well as the SFC. We will continue with the clause-by-clause examination today. But before we actually go into the clause-by-clause examination, we have a paper submitted by the SFC, the response on issues raised at the last meeting. Maybe the SFC representative would like to report on what the paper entails. Thank you. Before we go into the response, let me talk about the legislative intent of the 6 pieces of subsidiary legislation. As said before, in 2021, we have amended the SNF Ordinance and the company's legislation. We now are giving the implementation details. We have the framework in the 2021 Amendment Ordinance. We will promulgate for issuers some minimum requirements in the rules for this exercise. And from 2023 to 2024, the SFC has conducted extensive consultations, and the requirements are derived with consultation feedback. The rules would accommodate the needs of, say, elderly shareholders. It has struck a balance between the exchange, the listed companies, as well as securities holders. It also offers some flexibility to account for future developments. If the requirements are not met, we may take legal action. We do not want issuers to breach the law with no options or potential disputes with shareholders. It is not conducive to the implementation of the USM regime. When deriving the minimum requirements, we have in mind how we can implement administrative measures. For example, some code of conduct for the relevant stakeholders, like the listing rules, that would incorporate some requirements beyond the minimum requirements. In fact, with the developments in finance, with share registrars and other issuers, we have seen them benefit from the developments. For example, for shareholders, with the implementation of the USM regime, it will facilitate them in their opening of the accounts, and electronic communication can be adopted in future, with email addresses being designated as a means of communication. We have received some very good feedback from members such as Dr. Johnny, Mr. Chen Shu-hong, and Mr. Rin Kong. They have talked about how for personal information such as addresses and ID numbers. Mr. Yim Kong also talked about how we can adopt other ways to contact shareholders. These would all help us move towards digitalization. However, we have seen the potential impact being quite significant for some of the suggestions. For example, members know that we are scrutinizing the stablecoins bill as well. For email addresses, they would need specific definitions. we think we have to be careful whether to incorporate that in legislation and how it is to be incorporated in legislation if we decide that it has to be incorporated. For subsidiary legislation that we have proposed, the SFC has incorporated feedback from stakeholders when deriving these proposals. As for how we can further enhance the proposals, we keep an open mind. And after the scrutiny period, upon passage and implementation of the bill, there's still some time. The USM regime will come into effect mid-next year. The commencement notice for these pieces of subsidiary legislation will be introduced into the Council at the end of this year. We will make a report then to members. For example, a review of administrative measures and see what new measures may be needed. For the different existing measures, we will also see if there is any room for improvement. We want to make sure upon implementation of the USM regime, we can review the situation. And once we have more experience, we will enhance legislation some more. That is our vision. So, Chair, the SFC representative can perhaps go through the different clauses when we're done. Well, do you have any supplementary information to provide in relation to what the official said? Chair, do we need to brief members on our response, or should we proceed to clause-by-clause examination? I don't think you have to go through them one by one. Do you have to provide any supplementary information on top of the response given earlier by the FSTB representative? Not really, Chair. I think members gave feedback with reference to the feedback they got within their sectors. I think it's all for the good of the administration. In the end, the feedback may not be incorporated in legislation. But we understand that there may be impact on different stakeholders. The administration talked about how in future they may implement some administrative measures to tie in with legislation. We hope that the SFC and the administration will continue to consider feedback given by members. Let's proceed to clause-by-clause examination. We were on the USM rules, Part 3, Rule 12, SFC. When you're ready, please start the clause-by-clause examination. Excuse me, Ms. Kamen Khan. Sorry, Chair. I want to make a point on the response. I understand what is said by the administration and that there will be continuous reviews in future. They want to have some sort of flexibility so that they do not include everything in legislation. Instead, they would make use of codes of conduct. But I want to ask, what will the codes of conduct status be? Would it be binding on the regulatees in the sense that if they do not conform to the requirements, they will be punished? Mr. Leung, thank you. The SFC has all along been regulating securities dealers with the codes of conduct as well as the share registrars. In general, we would have codes of conduct that would address potential concerns. We will also have some requirements, and the ASRs, if they cannot conform to the requirements, we would see whether we need to change our level of regulation. If they do not conform to the specific requirements, we will need to, in the worst case scenario, review whether the ASR can continue to be approved or whether we have to impose further conditions for their operations. All right? So I would see that they are essentially licensing requirements for regulation. If they breach the requirements, you would have some sort of flexibility on how to discipline these firms, whether you will fine them, whether you will revoke their licenses. With the codes, it would be more convenient in a way, right? Yes. All right, before we go into clause by clause examination, the meeting will be all the way to 6:30. It's quite long, so we will have a break in between. SFC representative, please go into the clause by clause examination. Part 3, Rule 12.
12 of the USM rules. So Clause 12 deals with transfers by way of an instrument of transfer. Subclause 1 clarifies that the issuer has the prerogative to refuse the use of instruments of transfer to effect transfers that are in uncertificated form. Subclause 2 clarifies the particulars that the instrument of transfer must include. And Subclause 3 preserves the issuer's right to refuse to register a transfer on other grounds.
我哋停一停，陳仲尼議員。
多謝主席。主席啊，我就關心咧12條括弧3嗰度咧，頭先即係政府嘅同事都讀。
Sorry, I'm concerned about Sub-Rule 3. So it says specifically that Sub-Rule 1 does not limit or affect any other ground which the issuer may refuse to register a transfer of the prescribed securities. I think the scope may be too broad. Can the SFC representative elaborate on what grounds the issuer may refuse to register a transfer?
An issuer would have ability to refuse a transfer under, say, for example, their terms of issue or their articles or general law even. The idea of this legislation is not to affect any of that. So one example would be, for example, if the parties have placed an instrument of transfer before the company, but the details are inaccurate. For example, they are purporting to transfer 1,000 shares when they only have 800 shares. So the issuer should be entitled to reject that kind of a transfer, instrument of transfer. So the idea is that this legislation should not affect any rights that the issuer has currently in terms of how it deals with instruments of transfers or transfer requests.
主席，不過我頭先聽到同事佢答咧，嗰啲咪就應該係括弧2B 啊嗰啲講明。
But I think this has already been included in Sub-Rule 2B, say when the information is not accurate. I think Sub-Rule 2 would have already covered it. I think Sub-Rule 3 is a little too broad because it does not spell out the grounds specifically. So what scenarios do you have in mind for Sub-Rule 3 to apply? I think apart from what you mentioned earlier, do you have other scenarios?
That would be another grounds for refusal.
Oh, okay.
All right, Ms. Kamen Khan. Chair, I also want to ask about Rule 12.1b. It says the subject units are in uncertificated form. The issuer may refuse to register a transfer of securities. We're implementing a USM regime. How does this work exactly? Would you say specifically how a transfer in uncertificated form would be made?
in that case.
係啊，唔係好
So the idea is not to mandate when the issuer can use an instrument of transfer and when the issuer can use a specified request. And the reason for that is because we need to allow flexibility for the issuer to deal with unique and varied circumstances. The other concern is that we don't want the investor to demand how they can effect transfers. So for example, we don't want a situation where the shareholder actually holds the shares in uncertificated form, but insists on using an instrument of transfer. So the way we have done the legislation is basically to give the issuer the prerogative to decide that when they can refuse an instrument of transfer. And the general idea is that if the securities are in uncertificated form, it is the prerogative of the issuer to say, no, I'm not going to accept an instrument of transfer. And then likewise, if the securities are in certificated form, then it is the prerogative of the issuer to say, I'm not going to accept a specified request. And if they are in uncertificated form, it's the prerogative of the issuer to say, I'm not going to accept an instrument of transfer. So the basis of this is that the issuer and its share registrar will necessarily always endeavor to use the most effective means. They will not be able to use a specified request as a means to effect transfers of certificated securities. Likewise, if the securities are in uncertificated form, they would not be inclined to constantly receive instruments of transfer. So the idea here is to build in a degree of flexibility so that the issuer can deal with unique circumstances without the investor insisting on the method of use.
啊，主席，我諗就係由於我哋唔係好知道咩叫
Chair, I think it's because we have yet to get to the clause on specified request. We are somewhat confused. The SFC representative said investors, and I believe that would be the buying and selling parties of securities. If the securities are in uncertificated form, both the buying party and the selling party. Well, let me say this. Why does it prevent selling parties from selecting another form? Is it because with uncertificated securities, you would make sure it would be dealt with by specified requests? So you do not want to use instruments of transfer with their transfers, right? I think you need to accommodate how B works. Let me explain. For Rule 12.1, issuers may refuse certain transfers. And that would be transfers on the basis of instruments of transfer. To prevent any confusion, even the subject units are in uncertificated form. If securities holders want to make use of an instrument of transfer, the issuer has the right to refuse to register this transfer. I think we can look at what specified request says before we examine this clause, Mr. Rincon. On what Mr. Rock Chan asked, for Sub-Rule 3, I would like to ask the SFC representatives to justify this sub-rule because in a way, Sub-Rule 3 can refuse on any ground. You do have some notes here, but can you assure the public that this would have to be reasonable and legitimate when the issuers refuse to register the transfers? While it is not spelled out in law, is it possible for you to make sure you can pledge here that there would be justifications?
Be expected to act reasonably. Yeah.
我諗最主要個
Well, I think the main concern is, a point has been raised. Say, for example, it is claimed that a certain number of units are to be transferred, but then the number is accurate, so you won't allow that to be transferred, right? That has been cited as an example. Members are still wondering whether it is too broad. Now you're saying that it must be reasonable, even though in wording we don't actually see it being included. So are there any other questions? If not, then SFC, please continue with the cross-by-cross scrutiny.
So we move on to clause 13. So clause 13 deals with transfers by way of a specified request. Subclause 1 clarifies that the issuer has the prerogative to refuse the use of a specified request to effect transfers under certain circumstances, and these include where the securities are in certificated form, or are in the process of delisting. Subclause 2 clarifies what constitutes a specified request. So basically, it's 2 authenticated messages, one attributable to the transferor and the other to the transferee. Subclause 2 also clarifies the particulars that the specified request must include. Subclause 3 allows for a specified request to consist of a written instruction instead of an authenticated message in certain circumstances. And Subclause 4 preserves the issuer's right to refuse to register a transfer on other grounds.
我哋呢度停一停
Let's pause here. Mr. Tan Yueheng. Thank you, Chair. If I may ask a question about clause 13, 1D. That is, it is not reasonably practicable for the transfer to be registered on the basis of a specified request. I can clearly understand what's meant by 13(1)(a), B, and C. But then when it is said not reasonably practicable, I'm not clear about that. Can you cite the criteria, give us an example? Thank you.
監會
SFC.
For that question, in putting that particular paragraph in, our main concern was to tackle situations of takeover offers. So in a takeover situation, particularly where the takeover is a hostile takeover, the share registrar acting for the offeror will not be the same share registrar as the target company's share registrar. And so that share registrar will not be in a position to receive electronic instructions, and so it may be necessary for paper instructions to be provided. So that paragraph is designed for that scenario. We did not specifically cast that to refer to the takeover scenario in case there were other situations with similar practical limitations that we cannot currently think of, so that it could cater for those situations as well.
Fine. Well, I have got a question as well. 13(1)(c), that is in the process of delisting. Well, other than that, I think elsewhere mentions made about delisting. And in fact, our budget also mentioned about the need to review the delisting process. And there may be a separate board that may or may not happen in the long run, but then maybe at that time we still have to take a second look of the bill. Or are you saying that as currently drafted, you can cover the future developments?
主席，你嗰個問題我估你
Chair, in relation to your question, the main concern is that if we are to set up a platform for delisted companies for their trading, we have to look at the details involved. Well, to be frank, we haven't got any initial ideas. We have to wait for the details before we can comment on that. Well, in future, should there be a consensus to set up a platform for delisted companies to trade their shares, then we have to check whether the USM rules have to be amended correspondingly. Mr. Carmen Ken. Well, Chair, we're dealing with clause 13. Please explain the following and take it together with 12. 12 is about uncertificated, 13 is about certificated. What about the registration of the transfer? How is that going to be done? And in case that the issuer is to refuse it, I think it has to do with what you have said in the earlier clause, right?
So the idea is that where the shareholder is holding certificated securities, even if the transferee is going to hold in uncertificated form, the transfer will be effected by way of an instrument of transfer. This process is simply one that has been agreed among the share registrars and ourselves and the exchange because it's pragmatically the most sensible way forward. Because in any case, in that situation, you will need to attach the paper title document. So it makes sense to just allow that whole process to be a paper one. For all other situations where the securities are already in uncertificated form, the intention is that it would be electronic. As you will see, we have allowed for a scenario where a paper instruction may be received. So that is in 13.3. And the reason for that is twofold. One is to allow for some flexibility to deal with investors who may not be as tech savvy and who may need some assistance, especially elderly investors. Secondly, it's also to deal with the situation of joint holders, because as we understand, not all share registrars may be able to provide a facility, an electronic facility for joint holders from the get-go. So in order to allow for this degree of flexibility, 13.3 allows for instructions to be by way of paper to some extent. But the actual transfer, so what happens is that the paper instruction goes to the share registrar, and then the share registrar will then continue the entire process electronically. I don't know if that answers your question.
係主席，我諗
Thank you, Chair. Well, as far as I understand it, the registrar, the SFC, the exchange have all agreed about the arrangements that is depending on the subject security. If it is still certificated holding, and if the sell side is holding on to a paper certificate, even if the transferee would like to hold it in an uncertificated form, you still have to rely on paper form to facilitate the transfer, depending on the subject units, that is whether certificated or uncertificated. For clause 13, if at the time of transfer it is already held in uncertificated form, then the issuer may refuse to register a transfer instrument, right? So in the case of a certificated holding, and in relation to authenticated communication, please explain how it operates. Why you are saying that for investors, like elderly investors, they may want to keep the option under 13.3b. Are you worried that they may not have a mobile phone for them to issue an authenticated message? If not, how is the authenticated message to be sent?
Yeah, so it is intended, thank you for the question, it is intended for people who really can't deal with electronic transfers. It's really there just as an additional flexibility. I know that a lot of elderly investors are actually quite tech savvy. It's only really for a small population that may not be. And it's really there to allow some flexibility for the share registrar to deal with that situation. The concept there is, or the expectation there is that the investor may come to the the share registrar's counter and provide some sort of written instruction, and then the share registrar, based on that written instruction, might input the relevant information into their system, and so in that sense you still have an electronic transfer. So it's really just a way of finding a right balance to deal with all these different considerations.
好多謝。
好，下一位何記。
Next, Mr. Ho, our deputy convener.
2 questions. In the event that a written instruction is required, under any circumstances. Is there any process in place to expedite the authentication process to make sure that it's swift, it's done swiftly? Is there a process to expedite that so that no further delay? And also that it's mentioned there that it's as long as it's reasonable and also practicable. Can you give me like an example where it's not reasonable and not practical?
Sure, thank you for the question.
SFC.
First, your question was about expediting the transfers where there's a written instruction.
Yes.
So I think what we are anticipating is a situation where the person giving the written instruction is actually approaching the share registrar physically at their counter. And so all the relevant information would be received and input into the system. In terms of the time needed or the time within which these transfers need to be effected, the intention is that transfers by specified request must be done as soon as possible. And we have in the ASR code indicated that certain timelines. And in the case of transfers which involve deposits into CCAS, for example, the timeline we're looking at is within the T+2 settlement cycle.
Okay.
So because there are different scenarios, but we have elaborated on this in the ASR code to make sure, number one, that it's done on an as soon as practicable basis. So it's not that they have 2 days to sort of sit on it, but they do it as soon as practicable, and 2 days or whatever the period is the absolute maximum. And it's much shorter than the current 10 days.
Okay.
第二部分個問題有冇啲咩？
What about the second question?
Impractical.
I suppose if so yeah, you're right, this is an AND connector. So like I said, the tech-savvy carve-out and the carve-out for joint holders, that's the main reason for that paragraph B. So if in fact the share registrar has a facility for effecting transfers by authenticated instructions for joint holders, then we do not expect them to be relying on this. The reason we put that in is because we understand that it is an expensive system to build in for the share registrars, and they have quite a lot to do to implement USM from day one. So we understand the need to prioritize. But as and when they get their systems to be able to cater for joint holders, we do not expect them to be giving this option to such holders. In the case of tech-savvy holders, I guess there wouldn't really be such scenarios. I mean,
How do you determine someone who is tech-savvy or not tech-savvy?
I think I would expect the share registrar to take a common sense approach and look at all the circumstances.
Okay.
Yeah, and I should add that it's in the share registrar's interest and also the issuer's interest not to encourage this kind of instruction.
Fair enough.
Yeah.
OK， 可以繼續第14點可以繼續。
All right, clause 14 then.
Clause 14 deals with transfers from a minority shareholder to an offeror pursuant to a buyout under the company's ordinance. The CO provisions refer to the use of an instrument of transfer when effecting buyouts, and the relevant provision has actually been amended under the 2021 Amendment Ordinance to allow for these transfers to be effected by way of an instrument of transfer or a specified request. So against that background, Subclause 1 clarifies that Clause 14 applies in relation to a minority buyout under the CO. Subclause 2 clarifies the requirements where an instrument of transfer is used to effect the transfers from a minority shareholder to the offeror. So it specifies who may execute the instrument and the particulars to be included in the instrument. And Subclause 3 clarifies the requirements where a specified request is used to effect transfers from a minority shareholder to the offeror. I think just one point to add in light of members' earlier questions. The option is given to the offeror as to whether to use an instrument of transfer or a specified request, because depending on the specific circumstances of the case, they may not be able to use one or the other. So the idea is to give the the offeror the flexibility.
江玉歡議員。
Mr. Rincon. Thank you, Chair. If I may ask a minor point here. Just now in the earlier clauses, there is Rule 12 and Rule 13, the issuer may refuse to register. If I may have another point here, under the very special circumstances of refusal, does the issuer have the duty to inform the SFC as under the listing rules?
You will see that we have notification requirements. And one of the notification requirements is a half-yearly reporting. And one of the items that we would require them to report in that is whether they have refused any transfers.
Mr.
Mr. Kong. Thank you, Chair. Sorry. May I go back to clause 13? Actually, clause 13, 1 bracket C. The securities are in the process of delisting. Well, other than delisting, they may have the trading suspended. Does it mean that that would not be allowed as well? SFC.
Thank you for the question. So if I've understood it correctly, it's talking about where the trading is suspended. So when trading is suspended, there would not be any transfers anyway. So I'm not sure. Yeah, I suppose you can still deposit the shares into CCAS. I beg your pardon, yes, you're right. You can deposit the shares into CCAS. This would not apply in that scenario. We're not looking at that scenario where trading is suspended. We're looking at the scenario where the securities are in the process of delisting. Maybe just to expand why that requirement is in there, it's really because if the securities are already in the process of delisting, and for whatever reason, the investor wants to use a certificate, an instrument of title, an instrument of transfer, there's no real need to persist with the use of a specified request. That's the reason for putting paragraph C in.
Well, should we include suspension of trading as well? Because at the time of suspension of trading, no transfer is allowed. But would you not want to add suspension of trading as well? Mr. Leung, anything to add, please? If I may explain the matter once again, for 13C, in Chinese 除牌, delisting. In other words, the listed company would no longer be allowed to trade the shares in the exchange. As to the question you referred to, for a short period of time, owing to one reason or other, trading is suspended. So that's not been covered. Suspension and delisting are two different matters, so it's quite clear. So we are targeting at delisting, not suspension. Well, now, delisting should be covered, but suspension may last for a few hours, a few days, and then trading would resume, so that would not be affected. So for 1C, suspension should not and would not be covered. 1C only covers delisting, not covered, right?
OK，繼續嚇，陣間會。
Please continue, SFC.
So then we can. Sorry. Thank you, Mr. Chairman. So we can move then on to part 4, I think, which is on authenticated messages. So part 4 deals with the use and effect of authenticated messages. Clause 15 expands on what constitutes an authenticated message. So subclause 1 clarifies that the message must first relate to prescribed securities. Secondly, it must be sent using messaging facilities of the relevant recognized clearinghouse or ASR, and must be sent in accordance with the operating rules of those facilities. And thirdly, it must be one that is between either an issuer and a registered holder or transferee, or between an offeror and a registered holder. Subclause 2 expands on the meanings of various terms used in subclause 1. all the definitions are largely for drafting purposes, so they seek to identify the particular issuer or offeror or operating rules or registered holder in the context of subclause 1. And also in the case of the definition of operating rules, the definition seeks to clarify that it refers to rules or procedures that govern communication of messages using the facilities concerned.
江玉歡議員。
Ms. Doreen Kong. Thank you, Chair. With regard to the definition for operating rules, now I'm not familiar with the operation, but I'd like to ask why a recognized clearinghouse and approved securities registrar. Now for the latter, there is more elaboration. I'd like to know why the difference.
So the reason is because the term rules in the context of a recognized clearinghouse is already defined in Schedule 1 of the SFO, whereas not for ASRs.
好，我
Thank you. Now on this, I also have a question to ask. If I remember correctly, Ms. Khan asked a similar question. Now, there are some definitions. I'd like to know why the definitions are not put in the very beginning of a schedule or a rule. Why is it put here only?
要開咪。
The speaker is off mic. The microphone is not on. Now, usually, that's why we put there in section 2. Now, for the definitions for clause 15, they are applicable to clause 15, and that's the reason why they are put under clause 15. That means they are not applicable elsewhere. But last time, we came across a scenario when the definitions apply to the whole ordinance or subsidiary legislation, and so that's different. Now, if we talk about the electronic copy or hard copy form, the definition for the two forms, after consideration in our reply, we said that they will be kept in clause 8 because the definitions only apply to clause 8 because they were made with reference to relevant rules under the company's ordinance. Now, for consistency's sake, for clause 8, we have to add those definitions. In clause 6, electronic forms and hard copy forms were also used, but then is a rule unique to USM, and therefore it doesn't have to be consistent with the company's ordinance. So we consider that the hard copy form and electronic form, well, for those, the common definitions will apply, so there is no need to introduce them in clause 6. Thank you, Ms. Kong. I thank you, Chairman, for recalling that question. Now, Chair, in clause 15, in the definition part, registered holder and issuer, they were defined in section 2 already. Oh. Now you say in this rule, these definitions will apply. Then what about section 18 or clause 18? We see the term registered holder as well. So when we read 18, 1b, we've got the term registered holder. Should the definition in section 2 apply or in section 15 apply? This is my first question. And my second question is, do we really have to be that meticulous? Do we really have to redefine registered holder and issuer in clause 15? A question for the DOJ. DOJ, please. Thank you, Chair, and Ms. Kong for her question. Now, we have definitions in clause 15 because part 4 is about authenticated messages. So for the purpose of authenticated messages, we have definitions for issuers and registered holder. I just want to make a note here, Chair, and as it is absolutely necessary. Now, for instance, in a piece of legislation, now if somebody issues a letter, do you have to define, say, the author of a letter? Now, it's just a note. I'm not asking for any amendment. It's just my opinion. Thank you. Noted. Ms. Khan. Chair, I want to thank you for recalling that issue relating to Clause 8 and Clause 15. The administration response on the different treatments for Clause 8 and 15, well, I believe there is room for improvement. But then, this is not a main issue because the reason given for Clause 8 was to align with the terms in the company's ordinance. They had to define hard copy forms and soft copy forms. Now, in Clause 6 here, we also have here, and the ordinary meaning is used. Now, for hard copy form, once defined, the definition is much wider. It includes paper-based and other forms. So will you say that the situation in Clause 6 is clear enough without any definition? I think the reason given is a bit far-fetched. Can the administration respond, please? Mrs. Yi? Please switch on the microphone for Mr. Xi. Thank you, Ms. Khan, for your question. Yes, it is really needed because when we draft a piece of legislation, we consider the need. There is the need to ensure that there is alignment between the company's ordinance and the USM rules. Without Clause 8, we believe for Clause 6 in particular, there is more to soft copy form. For instance, it is a message sent to the electronic address of the person, and for the hard copy form, is sent to a last known address of the addressee. So in Clause 6, we have in Clause 8 we have clearer definitions for the two terms. So we can confirm that for Clause 6, we don't have to define the two terms in particular. No, I think the focus should be on the form rather than the way of delivery, because you talk about a printed copy or a copy that can be read. So the emphasis is not really on the mode of delivery. And if we want to ensure alignment with the company's ordinance, you can say that whenever these terms are used, then you will follow the definitions in the company's ordinance. Isn't that better? Because your approach will cause queries in the future. For instance, Ms. Khan asked how come you define them in Clause 15 and not elsewhere. Now, for register holders, will I have to go back to Section 2, and for Clause 15 alone, I refer to the definitions here. This is really a bit confusing. Can the SFC see whether there is any room for improvement? This may not have any, it may not be a significant point, but then still, there may be room to make the whole legislation more reader-friendly.
Move on to Clause 16. So Clause 16 deals with the attribution of authenticated messages. Subclause 1 provides that an authenticated message is attributable to a person if it is expressed or otherwise identifiable as being sent by or on behalf of that person. And Subclause 2 clarifies that an authenticated message may be attributable to more than one person, and where it is expressed or identified as being sent by one person on behalf of another, it is attributable to both of these persons. Moving then to Clause 17. Clause 17 clarifies who are to be regarded as addressees of authenticated messages. Subclause 1 provides that the addressee of an authenticated message is the person to whom the message is expressed to be addressed, or otherwise identifiable as being addressed. And Subclause 2 clarifies that the addressee, there can be more than one addressee, and where it is expressed as being addressed to one person on behalf of another, then both persons are to be regarded as addressees. Clauses 18 to 21, they deal with the effect of authenticated messages. So starting first with Clause 18, this delineates the extent to which these provisions apply. That means the provisions 18 to 21. Subclause 1 clarifies that the provisions apply only in respect of authenticated messages that relate to rights, benefits, or privileges attaching to prescribed securities, and the particulars of a registered holder of the prescribed securities. Subclause 2 clarifies that the provisions, that is clauses 19 to 21, apply without prejudice to the liability of any person for causing or permitting the message to contain inaccuracies or to be sent without authority. Clause 19 deals with authenticated messages sent by a principal. Subclause 1 clarifies the extent to which the provision applies. So it applies where the message is sent by a person on their own behalf, i.e. as principal. And Subclause 2 provides that the person sending as principal cannot deny that the information in the message is correct or that the person sent the message. Clause 20 deals with authenticated messages sent by an agent. Subclause 1 clarifies the extent to which this provision applies. So it applies where the message is sent by a person on behalf of another. Subclause 2 provides that the principal cannot deny that the message was sent with their authority or that the information in the message is correct. Subclause 3 provides that the agent cannot deny that they had authority to send the message or that they sent the message.
江玉歡議員。
主席，我有兩個問題。
Mr. Rincon, 2 questions. First, clause 19. 19.1. I'd like to ask if it can be disproved by fraud or mistake, and in clause 22, you have 2A, the so-called the principal's authority. Can you please clarify whether in actual authority and implied authority are both included?
Questions. So I think it's important to bear in mind that authenticated messages are sent through an electronic system and through a USI facility. So the way it works is that the person entering the instruction would have a username and password. So similar to what you do with online banking, for example. And the person sending the message, if it is an agent, would have the authority to send through that USI facility. So you asked whether the message can be, whether the authority, I think, can be disproved if there is no authority or if it's by mistake. Yeah. The way it would work is that so long as the USI facility is used and used in accordance with the terms of the operating rules, it will be binding on the person sending the message or the person to whom the message is attributable. And if there is any dispute as between, say, for example, a principal and an agent, then that would be something that they need to sort out. Because the concern is that the addressee should not be affected. The addressee should be entitled to rely on a message that has been sent in accordance with the operating rules and sent in accordance with the rules of the requirements of these provisions. So if there is some fraud between the principal and agent, for example, then that is a matter that they need to sort out.
主席，我想
Chair, further question. That means now for clause 19 and 20, now they are dealing with two different things. Under clause 19, even though there has been a mistake or fraud, so long as the authenticated message is sent, there is no turning back. Am I correct? The victim may have to report a case to the police. Now for clause 20, we're dealing with the agent and the principal. If the agent has no actual or implied authority, and if the message has been sent, it will be something between the principal and the agent. Is my understanding correct?
It's worth. Okay.
係有冇回答咗個問題冇其
Has the question been answered? No further question away. SFC, please go on.
Clause 21. Clause 21 clarifies the right of an addressee to rely on an authenticated message. Subclause 1 provides that an addressee may accept the following. First, that the information contained in the message was correct. Secondly, where the message is attributable to a person as principal, that the person sent the message. And where the message is attributable to a principal and an agent, that the message was sent by the agent with the principal's authority. Subclause 2 clarifies that an addressee may not accept the matters set out in Subclause 1 if they had actual notice of certain things. First is that any information in the message was incorrect. Secondly, the person expressed or identified in the message as having sent it did not in fact send it. And thirdly, the message was not sent with the authority of the principal expressed or identified in the message. So this is where the addressee has actual notice of these matters. Subclause 3 clarifies that an addressee who has actual notice of the matters mentioned in Subclause 2 may nevertheless rely on the message if at the time that they received the actual notice, it was not practicable for them to stop the processing of the message. And Subclause 4 clarifies that an addressee who is permitted by Clause 21 to accept any matter is not liable to any other person by reason of relying on the matter.
江玉歡議員。
主席，我有一個問題關於
Mr. Rincon, I have a question in relation to Subclause 2. Number 5, there must be actual notice. I'd like to ask whether that will exclude construction notice. If not, why? Why must it just be actual notice? Now, for 3, there is an interesting scenario when the addressee, even though the addressee is aware of Subclause 1, if it is already not reasonably practicable for him to stop the message, can you please give us some scenarios to illustrate this point? How come we will have a scenario under Subclause 3? Because under Subclause 3, the public may find it scary, so the thing will proceed regardless.
The intention is that it includes actual notice. The reason for that is if we are allowing, or rather if we are depriving the addressee of the ability to rely on the message, it is important that the notice that the reasons for that is that it actually knows that they should not be relying on that notice. So for that reason, we have limited that to actual notice and not included constructive notice. In terms of your scenarios for subsection 3, subclause 3, we don't really have specific scenarios in mind. The provision is really there to allow for the possibility that this might have happened, that when the when the addressee sent the message, they didn't have that awareness. But it might be, in the event that subsequently they did, and there's something they can do about it, we would want them to take steps. There is a balance here between wanting the transactions to go through as quickly as possible and how quickly they actually go through. So if they haven't actually gone through and the addressee somehow has notice of something in the message that is inaccurate, then it should not be able to allow that transaction to go through. The idea is really to strike a sort of balance between the rights of both parties while also allowing transactions to go through efficiently and quickly.
OK，可以繼續。
All right, please proceed, SFC representative.
Right, we move then to part 5, which is dematerialization on request of an investor. So clause 22 deals with dematerialization of prescribed securities at the request of a registered holder. Subclause 1 delineates the scope of clause 22. It notes that it only applies where the securities are participating securities and held in certificated form. Subclause 2 provides that the issuer may dematerialize such securities at the request of a registered holder, and it sets out the prerequisites for doing so. Subclause 3 clarifies when the requirement to receive title instrument doesn't apply. Subclause 4 to 6, these describe the issuer's obligation upon receiving a DMAT request. So these are that the issuer must, as soon as reasonably practicable, decide whether to accept or refuse the request. And if the request is accepted, the issuer must dematerialize the securities and cancel the title instrument. And if the request is refused, the issuer must, as soon as reasonably practicable, notify the holder of the refusal and give reasons. Subclause 7 notes that breach of the issuer's obligations under this clause without reasonable excuse is an offence, and it sets out the applicable penalties.
江玉歡議員。
主席，我想請問一下呢，就係喺第4嗰度嗱，呢個
Mr. In Kong, I have a question on sub-rule 4. On the dematerialization request, the requests are to be met as soon as reasonably practicable. And either one accepts or refuses the request, that would also be reasonably practicable as soon as possible. Can we set a period for the requests to be accepted or refused? And it says here if sub-rule 4 is contravened, there will be a further daily fine if it is a continuing offense. If you do not set a period for Rule 4, it just says as soon as reasonably practicable. How can you actually fine someone daily? Or even fine someone as a continuing offense? SFC representative.
So on the issue of why there is no time limit, the reason is because if we were to set a time limit, it would be in days. And in certain cases, you may not need days. And so the idea is that the issuer needs to do this as quickly as possible. That's really the main reason for not putting in a day. The code, however, does elaborate on what is absolutely maximum. So we strike a balance that way. In terms of the daily fine, our understanding, or I should say my understanding, maybe Mr. C will expand, is that it is for the court to decide what day, from which day to count the daily fines. I don't know if Mr. C wants to.
先生有冇啲咩補充？
Mr. C, thank you. Chair. Thank you, Mr. In Kong, for your questions. I think Ms. McAdam's explanation is quite appropriate. There are different elements to an offense. For reasonably practicable offenses, so to speak, the court would decide on what a period is reasonable, and starting from the end of that period, the offense would be seen as continuing. Chair, I'm not saying this has to be amended. I just want to give some notes here. If you do not say specifically what is deemed reasonable, you ask the court to decide every day, and the further fine is $700. If it's just 1 or 2 days, I don't think people will necessarily complain. I think in law it should be set in stone, because for consumers and investors, they will know what is wrong. They do not have to go to the court for everything for the court to determine what is reasonably practicable. It's just a note. I understand that in the guidelines or codes of conduct, there would be a period set.
In the code, also because we might want to keep that time as short as possible. So over time, we might want to shorten it. So we want to have that flexibility for keeping it in the code. At the beginning of implementation of USM, the share registrars may need a bit more time to sort of make accommodations. So that's why we've taken this approach. So there will be certainty as far as the investor is concerned.
好，主席，我希望呢，即係政府當局能夠到時。
I hope the administration can provide more guidelines for the public in future, because one may not be able to read it from the law. Dr. Tan Yueheng. Thank you, Chair. For sub-rule 6 of Rule 22. So when an issuer decides to refuse the dematerialization request, for this rule, it is about dematerialization at request. But here, it seems that they allow the issuer to refuse the dematerialization request. From what I heard earlier, this is something that does not happen normally. It is only an exception. In general, they would accept the dematerialization requests. If the issuer decides to refuse the request, what will actually happen? We don't want more certificated securities. In future, we want to go 100% uncertificated. So what will happen when an issuer refuses the dematerialization request? SFC representative.
Question. So a very valid question. Actually, we don't expect the issuer to refuse the dematerialization. The one scenario we can think of is where the certificate itself is questionable, where there is suspicion that the certificate itself is fraudulent, in which case they would be entitled to refuse to dematerialize the securities. And in that case, what will happen is that the whole shareholder base will be protected, because nobody wants a fraudulent certificate to be dematerialized and inflate the total shareholder volume.
OK， 冇其他跟進嘅話，咁啊，證監會可以繼續。
No follow-up questions, SFC representative. Please continue. We are on Rule 23.
Clause 23 deals with the dematerialization of prescribed securities at the request of a transferee. So subclause 1 delineates the scope of clause 23, and it notes that it only applies where the securities are participating securities held in certificated form, and where the issuer has received a request to register a transfer of them. Subclause 2 provides that the issuer may dematerialize such securities at the request of a transferee, and it sets out the prerequisites for doing so. So this includes that the transferee must be a system member, that it has received a dematerialization request and the relevant title instruments, and that the issuer is satisfied that the transfer may be registered. Subclause 3 clarifies when the requirement to receive title instruments doesn't apply. So this is where the governing provisions do not require such instrument to be issued, or where the issuer is satisfied that the instrument is lost or damaged. Subclause 4 clarifies that the disapplication of the requirement to receive title instruments, a title instrument that is lost or damaged, does not extend to other instruments that are not lost and damaged and that have to be submitted for the purposes of the DMAT request. Subclauses 5 to 7 describe the issuer's obligations upon receiving a DMAT request from a transferee. So it's again, the issuer must as soon as practicable decide whether to accept or refuse. If it accepts, the issuer must as soon as reasonably practicable register the transfer, dematerialize the securities, and cancel the instrument. And if the request is refused, the issuer must notify the transferee of the refusal and the reasons, and refuse to register the transfer. Subclause 8 notes that breach of the issuer's obligations without reasonable excuse is an offence, and it sets out the applicable penalties. Moving then to Clause 24. Clause 24 simply deals with the form of a DMAT request. If that's okay, we'll move on to Part 6. Part 6 deals with the issuer's authority to dematerialize, rematerialize, and issue new units in uncertificated form. Clause 25 deals with the dematerialization of prescribed securities at the initiative of an issuer. Subclause 1 delineates the scope of Clause 25, and it notes that it only applies where the securities are participating securities and held in certificated form. Subclause 2 provides that the issuer may, at its own initiative, dematerialize securities if certain prerequisites are met, and they are basically, one, that the holder or prospective transferee is a system member, and secondly, that the issuer has received the relevant title instruments. Subclause 3 clarifies when the requirement to receive title instruments doesn't apply, and as with the earlier provisions, it's where the governing provisions do not require instruments to be issued, or where the issuer is satisfied that the instrument is lost or damaged. Subclause 4 expands on some of the circumstances in which an issuer may dematerialize securities at its own initiative. It is not an exhaustive list. Subclause 5 describes the issuer's obligations if it decides to dematerialize the securities at its own initiative. And these are that the issuer must, as soon as reasonably practicable, dematerialize the securities and cancel the instruments. Subclause 6 notes that breach of the issuer's obligations without reasonable excuse is an offence, and it sets out the applicable penalties. Clause 26 deals with the issue of new certificates, with the issue of new units of securities in uncertificated form at the initiative of the issuer. Subclause 1 delineates the scope of the clause. Subclause 2 sets out the prerequisites for issuing new units in uncertificated form. Subclause 3 describes the issuer's obligations when issuing new units in uncertificated form. Moving then to Clause 27, this deals with the rematerialization of prescribed securities in limited circumstances. Subclause 1 delineates the scope of this clause. Subclause 2 describes the issuer's obligations, namely that the issuer must rematerialize any units that are in uncertificated form before they are delisted, and if their governing provisions so require, they must issue title instruments as soon as practicable thereafter. Subclause 3 clarifies that any title instruments issued to a recognized clearinghouse or its nominee must be in such number and denomination as specified by the clearinghouse or nominee. Subclause 4 notes the issuer's obligation to include certain further matters in a notice sent under Clause 6, and these are to clarify that the title instruments are to be issued following the rematerialization, and if so, when and how such instruments may be obtained. Subclause 5 notes that breach of the issuer's obligation under this clause without reasonable excuse is an offence and sets out the applicable penalties. Moving then to Part 7. Part 7 deals with facilitating the market's transition to full dematerialization. Clause 28 sets out the various mandatory obligations to be imposed on issuers. Subclause 1 mandates that all existing prescribed securities constituted under the laws of 4 key jurisdictions must become participating securities by the deadline specified in respect of them, or within 5 years of USM implementation, whichever is earlier. Subclause 2 mandates that all prescribed securities constituted under the laws of the 4 key jurisdictions and first listed after USM implementation must be in uncertificated form from the time of their listing or such later date as permitted under this clause. Subclause 3 mandates that subscription warrants and rights under a rights issue must be participating securities by the time they are listed, if at the time of their issue, the underlying securities are participating securities. Subclause 4 relates to Subclause 1 and clarifies how the deadline for existing prescribed securities is to be set. Namely, it is to be set by the corresponding parties, or if they fail to do so, by the SFC. And it is to be specified by notice in writing to the issuer. Subclauses 5 and 6 relate to Subclause 2, and they clarify the prerequisites for deferring the deadline for IPO securities to become participating securities. These are that the deferral is by the SCHK and only possible within the first year of USM implementation. And secondly, that the SCHK must be satisfied that there are exceptional circumstances justifying deferral, and that not granting deferral will unreasonably delay the intended listing date. Subclause 7 sets out a list of some of the factors that may be taken into account when deadlines are specified in respect of existing prescribed securities or IPO securities. Subclause 8 clarifies the deadlines may be revised or cancelled in the same manner as they are specified. Subclause 9 notes that breach of the mandatory obligations under subclauses 1 to 3 without reasonable excuse is an offence and sets out this applicable penalty. Subclause 10 expands on the meaning of terms used in clause 28.
江玉歡議員。
你呢個28咧好重要啦，即係成。
Ms. Doreen Kong, I think this is a very important provision. You talked about for sub-rule 9, an issuer without reasonable excuse would be committing an offence. It's something that they have to do, right? Can you explain what would constitute reasonable excuse for sub-rules 1 to 3?
Really to allow for any intervening events that may have occurred and that may require some change in the timeline, or that may make it unnecessary for the offeror, for the issuer to participate in USM. An obvious example would be if between the time of the date for the issuer being specified and the actual date, for whatever reason, the issuer has to delist. So that would be an obvious example where then it's no longer meaningful to proceed with this.
OK， 繼續。
All right, please continue.
So we move then to clauses 29 and 30. These impose restrictions and obligations in respect of prescribed securities that have become participating securities. Clause 29 prohibits the further issue of new units in certificated form. It also makes breach without reasonable excuse an offence and sets out the applicable penalty. Clause 30 prohibits the further issue of title instruments, and it makes breach without reasonable excuse an offence and sets out the applicable penalty. Clause 31 requires all units of those securities held within CCAS to be dematerialized within 6 months of the securities becoming participating. Again, it makes breach an offence and sets out the applicable penalties.
江玉歡議員。
主席，我想請問一下喺29同30。
Mr. Kong, I want to ask about rules 29 and 30. They are quite reasonable and valid. So when new units and instruments are to be issued, they can't be in certificated form. But why are there daily fines? I don't think there's a need for daily fines. Is this appropriate? Why are daily fines imposed? SFC representative.
Daily fine is really just an added incentive, an added deterrent against breach. So it would, the way we think about it is that it's bad enough that they don't comply, and the longer they wait, then the more they should be penalized. That's the logic.
咁即係話，主席，即係話嗱，你譬如20。
Chair, say if you don't want new units to be issued in uncertificated form, if they continue to do so, you would punish them. Yes.
OK， 可以繼續。
So we come.
Please continue.
These rules, which is clause 32. So Clause 32 provides for exemptions from the obligations under Part 7. Subclause 1 exempts securities that are in the process of delisting. Subclause 2 empowers the SFC to exempt or defer an issuer's obligations under Part 7. Subclauses 3 to 5 expand on the SFC's exemption power. Subclause 6 expands on the meaning of the term specified person.
Legal advisor, she has got a point to add. Thank you, Chair. In relation to the USM rules, there is LN 15. I would like to make a general supplement. Under LN 15, there are 13 new offences. All of them are not clearly spelled out as to whether the mens rea has to be proved. The LSD has made inquiries with the authority to check whether they are absolute offences. In other words, the prosecution does not have to prove the mens rea in committing the offence. The reply says that they are absolute offences. This is because they are regulatory in nature and the penalties imposed are light, and so the legal intention is to make them absolute offences. Just for your information. SFC, please.
可以繼續。
Please continue.
Thank you, Mr. Chairman. So we then
唔好意思，
Sorry. Ms. Ken, Chair, I want to know whether we have already covered Part 7. In other words, we have covered Rule 32 exemptions. Yes, we have just covered. What about the schedule? What about the schedule? Which places have been specified? That is, the USM would cover them. That is, the USM rules would apply. Currently, we have got Bermuda, Cayman Islands, Hong Kong, mainland of China. Where do we find the provision to allow us to amend the schedule? I think when we discuss the policy, if UK is ready or if another jurisdiction is ready, we would like to add it to the schedule. Where can we find a place to empower us to revise it? Mr. C, thank you, Ms. Ken, for your question. If we are to amend the schedule to USM rules, then we will have to rely on the empowering provision of enacting the USM rules. The SFC, via negative vetting, will amend the schedule. In other words, for this to be enacted, of course, it is still early. We are not sure because we're expecting it to be coming into effect in early 2026. Meanwhile, some jurisdictions would have discussion about the matter. Should there be changes, then we will be having the 4 places. And should another place or another jurisdiction be ready, then you will have to, can you name the provision of the SFO? Revising or amending the schedule, you may add more places or take away the places, or are we always having the 4 places? Where earlier on we talked about the 2021 Amendment Ordinance. In other words, we added to the SFO 101AA-M to empower the SFC to do so. 101AA-M, right? You mean the 2021 Ordinance, LN 17, or Ordinance number 17 of 2021, empowering the SFC to make rules. Can you not be more specific? You talked about 101AA, right? In relation to USM, we're talking about 101AA-M 1A. The related securities, etc. So we change it into uncertificated form and vice versa, and also facilitating the matter. And then at the end of the day, that is, if you go to the following page, the second paragraph, J, transition to full dematerialization. That is carrying out a timetable and in other ways to dematerialize the specified securities. That is 1018 AM, 1A, and 2J. For 2J, it doesn't actually mention the names of the places. They simply talk about setting out a timetable as well as the powers. Now, the timetable, we know, early 2026, using other forms to control the progress of dematerialization. Well, please tell us about where we can find the reference to the applicable jurisdiction. Well, for J, it's empowering, and there is a sort of a lot of room to maneuver. That is, either we can make it by reference to a place and also the timetable. So it's a very general empowering provision given to the SFC to set out the transitional details. Why don't you tell us that the names in the or jurisdictions in the schedule is amendable? For 28, it points to 28, Rule 28. But where can we find a place telling us that we can make adjustments? Well, under Cap 1, Interpretation and General Courses Ordinance, there is a general provision to talk about subsidiary legislation. So please go to Cap 1, Section 28. Cap 11C. Any subsidiary legislation may, by way of the relevant authority, be amended. So seldom do we say that a certain provision can be amended in future. Where would you cite this particular schedule? Where can we find a reference to the schedule in this set of rules? Well, you can look at the square bracket, Rule 28. Rule 28 refers to the schedule. Rule 28, we started by saying as to when you have to become a participating security. Which of 28? I found it. I knew it was 28, but where of 28? SFC.
So the way Rule 28 works is that the term specified prescribed securities is used in Clause 28.1 and in Clause 28.2. So those clauses start with the issuer of any specified prescribed securities. And then in Clause 28.10, there is a term specified prescribed securities, which is then defined by reference to the schedule. Hence the reference to Section 28, to Rule 28 in the schedule itself.
好，我諗因為時間係啦，即係差唔多。如果你
Yes, it's almost time to wrap this up. So after you have studied it, if you have further questions, you may follow them up later on. Let's continue.
The USM rules. So we can perhaps then move to the ASR rules, so the Securities and Futures Approved Securities Registrar rules.
Okay.
So we'll start with Clause 2, I suppose. Clause 2 is the interpretations provision, and it sets out various definitions used, various terms used in these rules. The first definition is available liquidity, and this essentially refers to the liquidity, the available amount of assets that are readily available to a an approved share registrar, approved securities registrar, I beg your pardon. The term capital is defined to include the share capital and retained earnings of the registrar. The term corresponding exchange company is defined by reference to the stock market listing rules. Essentially, it refers to the exchange company on which the securities are listed or to be listed. External borrowings is defined to refer to the amount calculated in accordance with the formula set out in the definition. Gearing ratio is again defined to refer to the percentage calculated in accordance with the formula set out in the definition. Issuer is defined in relation to any prescribed securities by reference to the USM rules. Issuer client is intended to refer to clients of an approved securities registrar that are issuers. Maximum gearing ratio refers to the percentage mentioned in Rule 83C, which we will come to. Minimum capital level refers to the amount mentioned in 83A, which again we will come to. Minimum liquidity level refers to the amount mentioned in Rule 83B, which we will come to. All of these definitions relate to financial resources requirements to be imposed on the ASR. Securities holder refers to the person who is or was entered in the register of holders as holding the securities. Securities registrar takes the definition from the stock market listing rules. Essentially, it refers to the person who keeps the ROM, who keeps the register of holders. Senior employee is defined by reference to Section 101 AAG 8 of the SFO. This again is introduced under the 2021 Amendment Ordinance. Service facilities refers to electronic facilities used by the ASR in providing securities registrar services, and it includes the UNSRT system. Surplus liquidity is defined to mean an amount calculated in accordance with the formula set out in that definition. Third-party money refers to money received by or on behalf of the registrar for a third person. Total operating expenses refer to the operating expenses and financing costs. And in these rules, there are references to an approved securities registrar's business and operations, and we clarify that this refers to their business and operations as an ASR.
講到呢度，我想提問呢，就喺
At this point, I would like to ask a question. In your interpretation clauses, you talk about senior employee and officer. Can you tell us the difference?
Senior employee, sorry, just give me a second, Mr. Chairman.
可以。
Sure.
So senior employee refers to a person who is employed by the applicant and who performs supervisory or managerial functions. In contrast, senior management refers to the people who are actually managing the operations of the ASR, so the sort of the directorate board and the more senior persons, if you like.
即係兩個都係高級不過啫。
Both are senior, but one is more senior than the other.
It depends on the particular ASR. In some cases, if it's a small operation, they might overlap. If it is not, they may not. So it depends.
明白 ，OK， 可以繼續。好。
Please continue.
We turn then to Clause 3, which is the specification of securities registrar services. So the term securities registrar services are the services that require an ASR approval if the person is going to provide it. Two of those services are already listed under the SFO, and so Clause 3 adds two additional services. One is the service of provided in connection with a public offer. It's where the share registrar makes available an electronic platform to accept applications and in an IPO. And the second service is where the share registrar provides corporate action related services. Subclause 3 includes some definitions, which corporate action, it basically defines it to mean any action taken or to be taken by the issuer. So it would include things like dividend issues, a rights offer, things like that. And public offer is defined to mean an offer of securities to the public for purchase or an invitation to the public to make offers to purchase those securities. Moving then to part 2, which are the general requirements. So the requirements relate to the ASR's premises, service facilities, management and governance, and insurance coverage. Clause 4 deals with the premises and essentially requires that the premises must be suitable, adequately and properly equipped, and where the premises are used for processing or storing information or data, they must be equipped for maintaining security, integrity, and ready accessibility. Clause 5 deals with service facilities, and the requirement there is that its service facilities must be equipped with adequate capacity, contingencies or facilities to meet contingency or emergencies, security arrangements, and technical support. Clause 6 deals with management and governance. This requires that the ASR must have competent personnel, effective internal control procedures, effective contingency measures, and business continuity arrangements. Clause 7 deals with insurance
我諗
coverage.
停一停，江玉歡議員。
Please pause there, Ms. Kong. Sorry, I'm a bit slow. Clause 4, premises. Must it be in Hong Kong?
We don't have a specific requirement that the premises should be in Hong Kong. However, in the ASR code, we do require certain things to be operated from Hong Kong. The reason is that some of the share registrars, they are rather global groups, so some of their premises might be located overseas. But the concern from our perspective is that if something needs to be done, if something needs to be followed up, if something needs to be communicated to them, people in Hong Kong must be there. And if they're not there, then whoever is overseas must be able to be contacted during Hong Kong hours. So that's the approach we take, and that's expanded in the ASR code.
OK，咁個 ASR code 咧，想請問主席，
For the ASR code, is it already ready?
It's there.
Thank you。
Ms. Carmen Can, Chair, for the service facilities under clause 5, well, in the definition, it is said that it will include a UNSRT system. Well, to facilitate our scrutiny, if we have already got a definition already contained in the 2021 Amendment Ordinance, can you not have it shown on a slide? Or right now, can you tell us where to find the UNSRT definition in the 2021 Amendment Ordinance? But sometimes you simply say including an UNSRT system. There may be others, and then it would be owned or used by the registrar. In other words, UNSRT is not mandatory, right?
So, the term UNSRT system is defined in Section 101 AAB of the SFO, which is added under the 2021 Amendment Ordinance. And that definition actually refers specifically to the system for enabling title to be evidenced and transferred. So the definition as such does not encompass all the other functions of an ASR. So an obvious one would be where the ASR provides electronic public offer related services. So if they have an electronic platform to receive applications in an IPO, that would not be the UNSRT system, but that would also be a service facility that we want to have regulatory oversight on. So hence the definition being broader than just UNSRT system.
咁係咪即係你嗰個最開始？
So, is it equivalent to the ESI facility included in your first PowerPoint presentation?
SI facility, what we mean is the platform for the investor to access the share registrar's system in order to manage and view their holdings. So that would be part of the computer systems and facilities of the ASR.
Chair, what does that mean? Is that system in existence? Can you tell us more about the system? And why have you say here, no matter whether it is owned or used by it?
Process of developing their systems and building them. The intention is for them to have their systems ready by the time of USM implementation, which is currently targeted for January 2026. As to your question about why the definition of service facilities includes facilities whether or not they are owned or used by the registrar, this is to allow for the possibility that the systems may, to some extent, be provided by a third party, either within the group or by someone outside the group.
我對嗰個使用有啲覺得奇怪啦，即係
I feel strange about the term use, regardless of whether it's being used or owned by that registrar. Now, we know what the big registrars are, but the system may not be owned by that ASR. But if you exclude use, then I find it strange. Well, the registrar has to use it. So can you stop it whether the facilities are owned by the registrar? So your question was, they're trying to define service facilities, including a UNSRT system. All right, I can understand that because it's including but not limited to. But why do you say whether or not the facilities are owned or used by the registrar? It has to be used by the registrar, right? Why do you include the word used? It may not be owned, but then it has to be used by that registrar.
Back, I'm sure there's a reason for it, which I can't recall right now, I'm afraid.
證監會史生係咪有？
Sorry, the words are
Mr. C?
share registrar.
要蕭小姐開翻咪要幫。
We turn on microphone for Ms. Siu.
Service facilities, whether they are used or owned by the share registrars, allow for the possibility that the share registrar may subcontract out the operations, the facilities that they are using to provide the services.
但係就算外判，
Well, even if it's subcontracted, you will be using that system, right? So if it's, I can understand why it is not owned by the registrar, but it has to be used by it, right?
Back on this issue, thank you.
呢個或者係啦，可以
Yes, please do. Please do. Let's put a marker here. All right. SFC, please continue.
So,
第6點、第7點啱啱。
With clause 7, we've just done clause 6.
So clause 7 deals with the insurance obligations of the ASR. So the requirement is that the ASR must ensure that it is covered by insurance that is reasonable, that is necessary to provide reasonable protection against risks associated with its business and operations. And the subclause 2 goes on to expand on this to some extent.
係江玉歡議員。
Mr. Rincon. 2A. The insured must include loss or damage attributable to a previous employees. I'd like to know the term of employment.
There's no limitation that we have in mind for that.
Okay. Okay. Thank you. Please go on.
Moving then to part 3, which is the financial resources. So clause 8 provides that the ASR must at all times maintain financial resources that comply with requirements specified under this rule or amended under this rule. Clause 2 provides that the Commission may, by notice in writing, specify financial resources requirements. Subclause 3 provides that these financial requirements imposed by the SFC may include requirements relating to the ASR's capital, relating to the ASR's available liquidity, and requirements relating to its gearing ratio. So the gearing ratio is the ASR's external borrowing over total equity. Subclause 4 talks about the Commission's power to amend or revoke financial resources requirements imposed under this rule. Clause 9 talks about notifications regarding financial resources. This provision is really intended as a requirement for the ASR to notify if their financial resources fall below certain levels or certain financial related events occur in relation to their business. And the idea is that if these triggers are hit, then the SFC can monitor their financial position more closely.
簡慧敏議員。
主席，我想問3。
Ms. Khan, a question in relation to clause 8.3b, the liquidity ratio. I think this does have an impact on the operation and compliance of the ASR. Now you say that is available liquidity must not fall below an amount equivalent to its total operating expenses projected for a specified number of months. Why can't you specify the number of months? Will SFC fix a number in relation to the operation of the ASR? So is the total operating expenses projected for a specified number of months? I'd like to know whether the trade has got any view on this as regards the number of months.
Yes, the idea is that a single number of months may not apply across all share registrars given their different size and scope of business. And so this gives us the flexibility to specify different amounts for different operations.
不過我諗跟進翻簡議員講呢個。
To follow up on the question by Ms. Khan, now the total operating cost, this has to be in relation to the company itself. As now, if the number of months is open here, then there can be big variations. I'd like to know whether this will be specified in your rules, because Ms. Khan would like some certainty here. For instance, when will the ASR be informed? Will the ASR be informed as soon as approval is given? Will it be made aware of the available liquidity that must be maintained throughout its operation?
In terms of when the share registrar will be informed, it will be informed at the time of its approval. And if there is a change, it will be informed when we instigate a change. I should just add that the number of months, the idea of the available liquidity requirement, a number of months, is to look at the operation and take a view on how long would it take to wind down that business if it became necessary. So the idea is that we want to make sure that if for whatever reason the ASR needs to wind down its business, the winding down can be done in an orderly manner. And so we must make sure that there is enough funding in order to achieve that. So the duration may differ for different share registrars depending on the size of their business, the scope of their business. There may also be share registrars who are only acting for themselves or only acting for one company. So the requirements would vary quite significantly.
主席，所以同樣地，即係 A。
So for A, the requirement on the financial resources and also the gearing ratio will depend on the ASR itself.
OK， 可以繼續。
Yes, please continue.
I think we've got to clause 10, right?
Okay.
So clause 10 expand.
江玉歡議員。
Ms. Doreen Kong. My apologies, Chair. I have a question in relation to Clause 9. Clause 9.2 has got a set of important incidents where the ASR should notify the SFC as soon as possible. Now you say as soon as possible in any event within 1 business day after becoming aware of that matter. So the ASR has to become aware of that matter first. What if it pretends that it is not aware of that matter? So how can you ensure, or how can you protect the public if the ASR claims that it is not aware of such a matter? Now, the ASR should be aware of such a matter. So why do you say becoming aware here? And then in Clause 9, you have got a series of things. Now, this is a critical issue. You require it to notify the Commission as soon as reasonably practicable in any event within a day. Now, what if disruption in services and facilities and operation? Now, you require the ASR to notify the Commission immediately after becoming aware of that matter. How come in 9, the requirement is within 1 business day after becoming aware, but for a reportable matter, the notification requirement is immediately after becoming aware? So why the difference here?
Yes,
SFC?
question. The reportable matters relate to matters concerning their service facilities or operations. So if a reportable matter arises, its impact on investors is immediate. So for example, it may be immediately impossible, just by way of example, for investors to effect transfers. So even while the share registrar or the securities registrar is working on a solution, we want to be in the loop. We want to know that, look, something's happened, so that we can monitor the situation, and because investors may also approach us directly. And so we are in the loop as early as possible. So the need for immediacy is there. In the context of the financial resources requirements, some of the levels here are sort of not yet at the levels that we have dictated, so they are slightly above. So they're close to breaching, but have not yet breached the financial resources requirements. So I suppose you could think of it in terms of the immediacy is not that great, but we still want to be informed as soon as possible. So you were also asking about, their becoming aware. Our understanding is that securities registrars should know what their financial position is at all times, and because there are requirements in terms of how the different lines of business are overseen and overseen and managed. So we do expect senior employees or certain staff to be aware of these and therefore be able to inform us as quickly as possible. We do not envisage persons who are approved as ASRs to not be aware of what their financial situation is.
好，主席啊，咁如果根據頭先解，
Well, following that explanation, someone from the senior management should know. So becoming aware should mean they ought to know, right?
We have relied on language that they are actually aware. I think if you start talking in terms of ought to know, we would be in a bit of a bind as to how to prove it. I mean, on what basis would we say that they ought to know? So, and the obligation here is on them. So once they are aware, the obligation is that they need to notify us.
OK，
Ms. Khan, a chair. Now, you're in the know when it comes to the securities trade. My question is somehow related to Ms. Khan's. Now, the term here is becomes aware, meaning actual knowledge. Understand that for the gearing ratio, the liquidity. I understand that you have built in a buffer. They have not yet reached that level, this level. For instance, 110% of the minimum capital level, on 120% of its minimum liquidity level. Now, below that, you have to be informed. So, Chair, would you say that the term ought to know will be better? Now, because these registrars hold property of the public. Now, when we have a USM system, the duty is quite onerous. So how do we strike a balance? I believe you have a model for your rules, right? If yes, can you tell us where your reference came from to say that the requirement is sufficient? And because there is that buffer, you think that the current drafting is sufficient? Now I have a related issue, but let's see if there is any supplement from the administration. It's really a bit hard to prove the state of ought to know. Now, for 3 consecutive days, why do you say here for 3 consecutive business days is not able to meet in whole or part any cause or demands? Why should it be 3 consecutive days instead of 2?
Question. So these levels are set by reference to equal requirements we have in respect of brokers. So we have drawn reference to the broker regulation in setting these out. We can dig out the relevant provision
明白
and
我諗即係
provide
亦
it.
都係個風險啦。
Noted. We talk about risks. Now, for brokers and registrars, we have to gauge whether the the risks are comparable. If yes, this is acceptable. If the risk on the part of brokers are higher, then we may have to reconsider. Yes, please go on, SFC. Any more on clause 10? If not, we can go on.
Clause 10. So these are requirements regarding notification under Rule 10. So this deals with requiring. So when, sorry, I beg your pardon, I got a bit lost. Right. So when an approved securities registrar is required to notify the Commission of a matter under Rule 9, full details of the matter and the reasons for it must also be included. And so subclause 2 expands on the matters that need to be set out in the notification to the SFC. So it includes matters such as what they are doing to redress the issue, and what they are doing to prevent, say, for example, the capital from falling below the financial resources requirements. And they must also provide the Commission with such other additional information as we may reasonably require. So Rule 10 basically is supplemental to Rule 9, the Rule 9 notification requirement.
Mr. Adrian Ho, Deputy Convener.
Under Rule 9 and 10, so any securities company are required to, when it becomes aware that its financial situation falls below a certain liquidity standard or, gearing ratio showing up above 50%, so they have the obligation to notify by written notice to the SFC. So are there any provisions as a penalty clause if they don't, and if the SFC were made aware of those situations from other means or sources, such as investors or anything like that, or losses has already been incurred because of such financial situation, are there any penalties clauses that will be imposed upon these securities companies?
Yeah, thank you for that question. So the way this regime works is pretty much similar to the way our broker regime works as well. So there is a disciplinary regime under the SFO, under Part 9 of the SFO. And so if there's any breach of any of the requirements here, it would be open to the SFC to take regulatory action against the ASR.
Okay.
And the regulatory action includes, reprimands, suspension of their approval, revocation of their approval, the usual stuff.
OK。
Moving then to Part 4 and the keeping of records. So Clause 11 requires or sets out the obligations relating to record keeping vis-a-vis the ASR. So key items include that they must have sufficient records. Their records must be sufficient to explain and reflect their financial position, demonstrate compliance with the ASR rules, account for all property and information received, enable all movements of property to be traced, enable all activities, transactions, and communication instructions to be traced, and account for all entries in the register of holders. Subclause 2 notes that the records must be retained for a period of not less than 7 years. Subclause 3 notes that the ASR must adopt all reasonably necessary procedures to guard against falsification and to facilitate discovery. Turning then to Clause 12. Clause 12.
或者我哋而家差唔多開到一半嘅時間，我哋可以休息。
Sorry, we're now halfway. Maybe we can take a 5-minute break. 5 minutes. And we'll come back. Thank you.